The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and welcome to this one case Zoom hearing for the Appeals Court. I'm Judge Milkey. With me is Judge Hodgens and Judge Toone, and together we are your panel for this single case hearing. The case is 2023 P267. The case is GLADYSH versus Grant and others, and we will hear first from Attorney Duahi, if I have got that.
Thank you very much. Members of the panel, may it please the court, good morning. My name is Krista Duahi, and I'm an attorney at Community Legal Aid, and I represent the defendant, Appellant Josephus Grant. As the court is aware, this case turns on one issue: whether Mid-Island strictly complied with the HUD requirements when it foreclosed on Mr. Grant's FHA loan. Specifically, did Mid-Island send by certified mail a face-to-face meeting solicitation letter? I will focus the entirety of my time this morning on Mr. Grant's primary issue on appeal, that the housing court abused its discretion when it admitted Mid-Island's highly prejudicial trial evidence that was produced well after the close of fact discovery. This evidence impacted the integrity of the verdict and deprived Mr. Grant of his basic right to a fair trial. This abuse of discretion in the court below warrants remand for three reasons. First, the records that Mid-Island admitted at trial, specifically trial exhibits 4 and 5. 4 was a purported spreadsheet of daily mailing of solicitation letters by loan servicer Senlar, and exhibit 5, which is a purported receipt from the post office, also held by loan servicer Senlar. These records, your honors, should have been excluded by the court as a sanction for Mid-Island's egregious discovery violations. Second, even if these records were not the product of its discovery violations, the court should have excluded them because on their face, they were objectively unreliable. And third, Mr. Grant's substantial rights were injuriously affected by the court's rulings on these critical exhibits. The late evidence, exhibits 4 and 5, was the decisive factor for the jury in this case. They would have reached a different—
Yes, but wasn't there ample time to prepare for trial? Wasn't there about 7 months between the time that this material was produced on the trial?
So this evidence was produced around July 30th of 2021. It was revealed as a part of a briefing on Mr. Grant's motion for reconsideration of a denial of his summary judgment motion. July 30th, 2019 was also when, through his pro bono LAR counsel, Mr. Grant objected and asked the court to preclude this evidence, also a part of the summary judgment briefing on reconsideration. The court took this under advisement. It did not rule on this until October 27th of 2021, many months later. So soon thereafter, less than 2 weeks, there was a case management conference in November. The case barrels forward. Trial happens March 7th of 2022. So the answer, with all due respect, Your Honor, is no, there was not enough evidence. By the time the evidence was thrust upon the court—
no, enough time. My question was there enough time between the period when this material was produced and the trial itself? In other words, how was your client prejudiced by the delayed disclosure of this material?
As a pro se litigant, he was unable to overcome the surprise. For many years, the entirety of the litigation preceding the reveal of this evidence in July 30th of 2021, Appellee Mid-Island maintain a completely contradictory position that the certified letter was sent by first-class mail. This was the issue that all the parties agreed on for multiple years, including when the case was scheduled to be trial ready in February of 2020. So while he was aware of this evidence in July of 2021, the court made no ruling. Mr. Grant was hoping that the court would have excluded it upon his request. So
But he was at that point aware of the existence of the letter.
He was.
So couldn't he have prepared for the eventuality that it could come in?
Theoretically, yes, Your Honor. He, as a pro se litigant, is unfortunately navigating a very complex civil case on his own, except with the exception of sporadic LAR pro bono counsel that can come in. As a pro se litigant, he's operating in scarcity to find assistance where he can. With something as sensational as documentary evidence like this, in a vacuum, I submit that Mr. Grant would have needed to do a whole host of things to be able to properly vet this evidence, including Rule 45 subpoenas, taking depositions of the third party SENLAR. They are not a party to this case. Mr. Crawford, who was the witness who came in and for whom Mid-Island introduced this evidence, was not even named in the pretrial memo. Now, Mr. Grant didn't include that in his brief, but it is important as the court looks through the entirety of the record to note the many missteps of the court below in essentially, I mean, the housing court has, of course, discretion, but their discretion in this case, it really turned into deference. And that's how Mr. Grant's substantial rights were impacted, because his request was utterly ignored by the housing court for preclusion. Yet Mid-Island gets to use this evidence. It's the centerpiece of their case. There's no other evidence that they have with respect to proof of mailing. So while he had the documents, number one, he didn't know what the court would do with them until the end of October 2021. And by that time, the train had left the station and the case was scheduled for trial soon thereafter. And Mr. Grant was pro se. So the implications in a case like this are that, and Mr. Grant respectfully submits that the housing court has an independent duty. They have a duty to ensure, especially where there's a pro se litigant, that there's a level playing field. And when a discovery rule, like as basic as properly amending interrogatories or document requests, is violated, it essentially gives license to trial by ambush, with all due respect. The housing court it was incumbent on them to at least acknowledge the nature of Mr. Grant's requests that were very specifically detailed in his motion for reconsideration, that this evidence was unreliable, that it was not produced in accordance with discovery rules. It was years after the close of discovery. And the impact was not without consequence.
But the jury though was the verdicts flipped very specific questions here. The jury was asked about all of this and asked about whether the letter was sent and so forth, and gave very specific, answers to those questions. So didn't your client, ultimately he got his day in court, so to speak, and the jury just didn't side with him. And in fact, didn't the judge also indicate that he did an outstanding job, or words to that effect, in representing himself in front of the jury?
Mr. Grant appreciated the court's comments on his respectability. However, he is as a pro se litigant who had to, be very resourceful in trying to pull in resources to help him litigate this case. He did have his day in court, Your Honor, but it was not a meaningful presentation of the facts of this case, because Mid-Island was able to call all the shots with respect to discovery. They were able to hold a position where the court on many occasions issued rulings including findings of fact that included an undisputed fact that the solicitation letter was sent first-class mail. This history and context is critically important on why preclusion was the appropriate remedy in the pretrial stage for this evidence, because it was so consequential. It was the only evidence in the case.
But counsel, at this point, the issue isn't should it be excluded, but did the judge abuse his discretion in not excluding? And help us understand your argument about why it crosses that standard.
The housing court gave no attention. It paid no attention to Mr. Grant's preclusion request in the summary judgment reconsideration briefing. It did not even consider or meaningfully analyze the issues that Mr. Grant was bringing to the court's attention, the deep prejudice that he suffered in having, the only evidence be an about face 180 degrees. So the conduct of the court, while they do have wide latitude, it was lopsided. It was completely one-sided. In their failure to take any action whatsoever to sanction Mid-Island for their discovery violations, the court was abusive with respect to the rights of Mr. Grant. And I would like.
I'm sorry, what was Mid-Island's explanation for the late disclosure?
There was no explanation. There was no explanation given. There wasn't. There was, and the court didn't entertain this issue in any of its rulings. There was some trial testimony that I read that counsel for Mid-Island asked why this was late of the witness, and he said, well, only I knew where to look for it. There's lots of records. So there really wasn't a clear and persuasive explanation as to why wholly contradictory evidence was produced multiple years after the close of fact discovery. And the court allowed it. And that, Justice Milkey, is why there was a clear abuse of discretion in this case. Because
just so that I'm clear, do you raise an issue of good faith here, as opposed to we found this document, which plainly is in the mortgage company's interest to reveal quickly. We found it late and we turned it over once we found it.
Mr. Grant isn't making an argument regarding good faith. His argument is about the propriety of pretrial process and of discovery rules, that where there's a violation, there should be some consequences. Accountability matters. He was asking for accountability in the pretrial stage to the best of his ability with limited counsel, and there was no consideration given to that request for preclusion. And in fact, the court, instead of hitting the pause button and asserting itself, which it should do in its traditional role as judge, where there's some risk of exploitation of a self-represented party, the court abdicated its role. That abdication constitutes an abuse of discretion.
Well, I mean, that's a little bit harsh, isn't it? Put that on the judge, because during the pendency of the case, correct me if I'm wrong, but your client was living, I think, for a number of years, maybe 7 years, or it was a lengthy period of time. He's living for free at the property. He's not paying his mortgage. He's not paying any real estate taxes. He's not paying insurance. It's the mortgage company that has to pick up the carrying costs. So he's not being harmed, in a sense, by any delay occasioned by the judge in sitting on this for several months before he issued a decision, right?
He was, he's following his rights to litigate his claims in the most fulsome way possible. I'm not aware in the record of prejudice that the third-party purchaser alleged due to the length of this case. And in fact, Mid-Island alleged that the reconsideration motion was prejudicial and shouldn't be considered, which was ironic given their revealing this surprise 11th hour evidence just a few weeks later. As we close, Your Honors, I see that we're just running out of time, but Mr. Grant prevails on the court to acknowledge the conduct of the housing court, the synergistic effects of the housing court's failure to take action at Mr. Grant's requests in culmination with his trial objections to exclude this evidence, which was unduly prejudicial to him. It had a synergistic effect of depriving him of a right to a fair trial before a jury. And he asked the court hold the housing court accountable and remand the matter for further proceedings. Thank you.
Before we leave you, do either of my colleagues have any further questions?
No, thank you.
Seeing none, thank you very much, counsel. We will now hear from Attorney Santo Lucito.
That's correct. Good morning, Your Honors, and may it please the court. Thomas Santalicito for Mid-Island Mortgage Corporation. Mid-Island participates in this appeal for the sole purpose of asking that the court affirm the trial court's decision concerning Mr. Grant's counterclaims against my client. My client is not here to defend the foreclosure sale in all respects, nor does it take a position concerning the judgment for possession that issued in favor of Mr. GLADYSH. It's also important to note that although Mr. Grant's counterclaims were not exactly pleaded clearly, the sole issue before the court is concerning my client is Mr. Grant's claim for breach of contract for failing to comply with the applicable HUD regulations. These are claims for which Mr. Grant and not my client has the burden of proof. So to prevail, Mr. Grant needs to show that my client breached contractual obligations and was damaged as a result. It's not on my client to show that the foreclosure complied with all regulations and statutes in all respects. And that's for purposes of my client's portion of the case. Your Honor, there's several issues raised in this appeal, but it looks like the focus is on the late discovery of the certified mail evidence that came into the record during the summary judgment phase of the case. After that evidence had been disclosed to the trial court, Mr. Grant did object to it in the context of summary judgment motion. He did not either at that time or subsequently file a motion seeking discovery sanctions. He failed to file a motion at trial in limine to exclude the evidence for the timeliness of its production. He made some objections to the introduction of this evidence, but not on the basis of timeliness. And having failed to lodge a timely objection or seek discovery sanctions, Mr. Grant's precluded from doing so now. As the court correctly pointed out, the trial court had discretion, and the other side needs to show that it abused its discretion in allowing this evidence. And I think when weighing the evidence as a whole, the probative value of the evidence, of the certified mail evidence showing that the face-to-face letter had been sent by certified mail, outweighs any potential prejudice to Mr. Grant, who had, as Your Honor pointed out, more than 7 months to consider the evidence.
But why was it, the evidence was kind of central to the issues being tried. So can you just tell us why it wasn't disclosed until after summary judgment? Why wouldn't this be something that the bank will be able to sort of identify right away? It's key to the litigation.
Sure, Your Honor. The witness from my client's servicer testified to that very point during the trial. It can be found at around page 722 of the record appendix, where the witness stated he wasn't sure why it took so long for that evidence to come forward. Mr. Grant had the opportunity to cross-examine the witness, who indicated that the certified mail records had been archived in some fashion and that he knew where to look for them because he had specialized training and had dealt with this issue in prior cases. I can't speak for any other reason why it wasn't produced previously, other than, again, what's in the record as far as the testimony of the witness. He did testify that he wasn't sure why it wasn't produced earlier, but He knew where to find it. He brought it to the court's attention by way of affidavit as soon as the evidence was discovered. And
Surely someone else at the bank knew that this was Mr. Crawford was the right person to find these documents, right? I mean, there seems to be a fundamental failure here to, if not locate the documents right away, locate the person who knew where the documents were, because that was really the key issue here. So I'm saying I wish they'd called me earlier isn't really enough to explain the bank's failure in this respect.
no, understood, Your Honor. And I don't have an explanation for what happened at the earlier phase of the case, other than through Mr. Crawford's testimony that he knew where to look for the evidence, and once he did, he was able to find and produce it. And again, the bottom line is, once the evidence had been discovered, Mr. Grant failed to seek discovery sanctions, failed to lodge an objection to the evidence at trial, failed to file a motion in limine, failed to take action to preserve his objection to the evidence.
Now, and you're right in all that you say, but isn't there some force to what Mr. Grant is saying, in that not just the fact that he's a pro se litigant, but it's sort of a David and Goliath case here, where you have an individual who's run into some difficult times, behind on his mortgage, and you have the mortgage company that has all the resources in the world at its disposal, from lawyers to staff, and should really have all its ducks in a row for proceeding down the foreclosure route. And it turns out all the ducks aren't in a row. And it seems that the negative effects of that end up falling upon Mr. Grant.
Yeah, Your Honor, I understand your point with respect to Mr. Grant's circumstances. What I will respectfully disagree with is that Mid-Island's ducks were not in a row. The fact is, stripping away these evidentiary issues, Mid-Island complied with HUD's regulation. It did send Mr. Grant the letter offering a face-to-face meeting. That letter had been sent via certified mail, and that evidence may have come upon the parties late, and I understand that it should have come earlier. I can't explain why, other than through the trial testimony, why it wasn't produced earlier in the case. But the bottom line is, my client did comply with the regulation. It did send the requisite letter by certified mail, and did send an agent to the property in an effort to arrange a face-to-face meeting. Those two prongs are what's required by the regulation, and my client did comply with both of those prongs.
Well, let me ask you about that, because the letter itself appears as a number of in a number of places in the record, and in it says you may request a face-to-face interview with us to discuss your options. But does that really comport with what HUD requires, where the HUD regulation is for reasonable efforts? It should be a reasonable effort to arrange such a meeting. So, in other words, I didn't see anywhere in the letter, well, there's certainly no reference in the letter to the HUD regulation anywhere that would enable Mr. Grant to look it up on the internet. But it doesn't use the language of the regulation either. It says, well, you may request a face-to-face interview. Well, is that really arranging a meeting with the borrower?
Yeah, the regulation requires that the mortgagee engage in reasonable efforts to arrange a meeting, and a letter saying, we're happy to conduct a meeting with you, contact us at this 800 number. I believe that is sufficient to meet the burden of the regulation. And again, Your Honor, I'll point to the fact that again, the burden of proof here for these counterclaims is not on my client to show that it complied. It's on Mr. Grant to show that it didn't comply, giving rise to a breach of contract. And the burden's on Mr. Grant to show that that letter was somehow defective. I'd also state that the sufficiency of the letter was never at issue at either during the trial or the summary judgment phase of the case. Mr. Grant allowed the introduction of the letter without objection, and there was no argument specifically that the letter was defective on its face. So that argument had never surfaced, and again, I understand and respect Your Honor's point, but that argument had never been asserted earlier in the case, and I would argue that it's not appropriate to do so now. The sufficiency of the letter was never at issue. It was whether the letter had been sent by a certified mail. And again, that evidence came into the case late, admittedly. I can't explain the reason why, but there was never a motion for sanctions. And even if there had been a motion for sanctions, I don't know that exclusion would have been an appropriate sanction under these circumstances, just given that the letter shows that my client complied with its certified mail requirements under the regulation. With that, I'm happy to address any other questions the court may have. Otherwise, I can rest on my brief here.
Do either of my colleagues have any further questions?
No, thank you.
Thank you.
Hearing none, the case is submitted. We thank you both. Excellent arguments on both sides. And I will see my two colleagues in courtroom 4. Thank you very much.
Thank you, Your Honors. Have a good day.
You too.